So this is a real-life example of the principle I was talking about earlier, that if there is a termination, and if the employer then says to the employee, oh, come back to work for the notice period or come back to work at all, then the statutory payment in Ontario is due and owing on termination, and the employer can't escape that. And if the employee insists upon it, then it should be paid. And if it's not paid, then that's likely a good defense for not continuing in the notice period of the offer or the offer of reemployment. There's no cases that have argued this, but in my view, it's crystal clear. So this is a real-life example that went to trial. The case is called Chevalier versus Active Tire. And the plaintiff in that case had worked for the company for 33 years. He was told by the company that he was laid off, which for reasons I'll explain later was an act of termination. The employer thought it had the right to lay him off under the statute, but that's an unnecessary complication for the moment. So basically, he was terminated, and then he went to a lawyer. The lawyer sued. And after they were served with the lawsuit, the company said, oh, we've changed our mind. We made a mistake. Come back to work. And the employee, and I say quite naturally, said, I don't think so, and maintained the lawsuit. Well, the case went to trial, and the trial judge found that there was nothing acrimonious about the working relationship and said the employee is going to lose the case. Not only did the employee lose the case, the employee had to pay $50,000 in legal costs to the employer. Never mind what he had to pay to his own lawyer. The case went to the Court of Appeal, and the Court of Appeal upheld the trial judgment and said, sorry, you were terminated. They made an offer for you to come back to work. Should have taken it, have a nice day, and lost the appeal. Now, what was not argued in that case and should have been is that on the moment of termination, the employer had an obligation to pay the statutory sums in Ontario, which in this case would have been 34 weeks' pay, and the math comes to about $33,000. That argument wasn't raised, and it should have been. And poor Mr. Chevalier lost his case, and not only should he have been entitled to the $33,000 on termination, but that's also a legitimate argument not to continue in the employ of the company once it offered him re-employment. He could properly say, I'm sorry, you're not complying with the provincial statute, you're offside, and I don't have to return to work. And he could have probably got an additional award of aggravated damages to top it off. And normally, given 33 years of employment, easily he would have been entitled to 18 to 24 months compensation. The statutory payment would come off that. But still, it was a very, very unfortunate event for Mr. Chevalier. It indicates that what the position should have been in, should have argued, should have won, and should have won big. Instead, he was out $50,000 in legal costs to the other side, never mind the costs of the appeal, which were probably around $5,000 to $10,000 to the other side. So a complete disaster for Mr. Chevalier, and it could have been avoided. So be smart and beware.